Justice Nafsa made it very clear from the start what the case had been about.
This appeal does not concern the merits of a decision taken on the 6th of April 2009 by the first respondent, Mr. Mokotedi Mshe, the then acting National Director of Public Prosecutions, to discontinue a prosecution against the third respondent, Mr. Jacob Zuma, who is presently the President of the Republic of South Africa, on corruption charges.
Accessing records that informed the NPA's decision to drop the charges was a different matter. The SCA ruled the DA could have a limited look at these records. They include documents and material that informed the decision to withdraw the charges, but exclude the confidential written and oral presentations made on Zuma's behalf. The NPA has been ordered to submit these records to the Registrar of the Appeal Court within 14 days. The DA will then have to apply for access to the records. Both Zuma and the NPA have been ordered to pay the DA's legal costs. Palesa Mathani, SABC News, Bloemfontein.
Following the judgment, the NPA must make available the requested record of the decision it used to drop charges against President Zuma, and those documents could be potentially damaging. The court says it's in the public interest to allow the DA access to those papers, but the NPA is adamant that its earlier decision will stand the test of any court.
This judgment has no direct impact on the actual decision by Advocate Mshe not to proceed with the prosecution, but these were preliminary issues on whether the DA has a right to even request for the reduced records.
But an analyst disagrees. He believes a review of the papers could lead to the president being investigated again.
It does have significance because it's bound to reopen old wounds. It's bound to reopen the whole question of whether, in fact, the corruption case against him should or should not have continued. And it therefore raises the question about whether or not he can and will be still convicted for those charges, those very serious charges. And in this country, there's no presidential immunity, so in theory, the president could face those corruption charges once again.
The DA has welcomed the Supreme Court's ruling.
Ironically, the defense of the National Director of Public Prosecution in the review application said that we were politically motivated. The judge said not at all. We're in fact bound by the Constitution, our own Constitution and the national Constitution, to protect the Constitution and to act in the public interest.
The presidency says it is still to study the judgment.
The decision taken by the National Director of Public Prosecution in April 2006 not to prosecute President Jacob Zuma still stands. In fact, the judgment opens with the remark that this appeal does not affect that decision at all.
But Zille expects that the presidency and the NPA will now use every legal trick in the book to delay, stall and sidetrack proceedings. Manelisi Tubase, SABC News, Parliament.